So yesterday we were talking, and you were telling me that you teach people on how to pass, or they used to teach people how to pass the bar exam. Can you tell me again?
Okay, so we start with the premise that the existence of the bar exam is to tell somebody who's legally authorized that you know enough about the law and how it works to be a lawyer. And the test for that is called the bar exam. And the bar exam is in two parts. One is multiple choice, and it's called the multi-state section of the bar. And the other part is essays. So a professor, that same professor who chose me to be his TA, teaching assistant, was the person who took on minority students for every bar exam, and he would teach them how to take the exam. He did not teach the law. You were still required to study for the bar exam, study the law, go to class, graduate, and know something about the law and how it applies and how people decide who wins and who loses in legal challenges before courts. But he got a promotion, and he became the public advocate for New Jersey. His name was Al Slocum, Professor Al Slocum. And when he became the public advocate, he could not do that any longer. The rules of conduct prevented that because those students could very easily have cases before him or something. So he chose me to continue his tradition because I had been his TA, so he knew how I approached teaching. He chose me to continue that practice, and I started out with just 2 students. The same young woman who died was one of them, and another friend was the other. And they had not been successful. They had taken the bar twice, and one had taken it twice, and one had taken it for the first time. So assuming that a person would do all the work to study the law and get prepared for the bar exam, the key to sometimes, in most cases, the key to who passes and who fails has to do with whether you clerked in your daddy's law firm or your cousin's law firm and you knew some things about how to do law. But more often than not, the essay portion would be where people would fail. And it's very important because the multiple choice part of it, you could sort of bank. They called it banking it. And you could use that in different states. In New Jersey, the biggest challenge was passing the essay portion. So Professor Slocum taught us, because I was one of the students that he mentored in this process. When minorities take the bar, we have the challenge of not only knowing the answers, the law, how to write and answer the question, but we had additional challenges very often in how we wrote. Now, essays are based on writing. So if a question says, write a legal memorandum, and you start out saying, the issue is, did he commit murder? You've already failed because you failed to answer what we call the call of the question. The call of the question was, write a legal memorandum. So if you started your exam, you didn't say to, from, regarding, and the date, you've not shown the reader of your exam that you even know what a legal memorandum is, because they all start out the same way, to, from, because you're answering some question that has been posed. The second problem would be understanding how to answer what they asked you. If they give you a scenario, for example, and I can only do this by example, bar question was, John came home from work, saw his girlfriend, fiance, on his front porch with his best friend kissing. And John had stopped on the way. He had 3 drinks. And he became so enraged when he saw them that he went in his trunk where he had a hunting rifle, got his hunting rifle off, went to the porch and killed his best friend and his girlfriend. What charges could he face? So you have to know all kinds of things like, Was he of sound mind? Was it voluntary? Was it involuntary? Could he control his emotions? Could he not? Was he so enraged at seeing his fiance and his best friend? Was he influenced by the fact that he had stopped by the bar on the way in? All of things that you could discuss in determining if you know what first-degree murder is. That has to be intent, and you have to say whether it's second degree, whether it was involuntary homicide because he was drunk, or was it voluntary because he was drunk, or involuntary because he couldn't control his emotion. Whatever it was, you'd have to be able to discuss all that. So that's the second thing, knowing the rules of law that apply to those facts. But the largest problem sometimes is that you run out of time because minorities have to think about what they're writing, not just in terms of substance and context, but whether the subject and the verb match, whether the grammar is correct. And very often folk write in a stream of consciousness writing. So somebody thought to analyze, when white people write, they write the way they speak. So if they're speaking perfect English or correct English, they don't have to think about it is she, it is her, it is whatever. And if the subject and the verb match and the tenses are correct, because you get graded not just on what you say, how you say it, and to whom you're writing. Sometimes you get judged on how well you wrote it.
Wow. So
very often, minorities have to think about sentence structure.
So we have to translate.
And you have to, that's right. You have to write it in a way that doesn't give you away. So
yeah, that's what happened to me. English is my second language.
Right.
And even though I've been here for 20 years, I still have to translate a lot of the stuff to make it kind of sound American way. And when I mean Americans, white. Right.
You mean white.
Yeah.
And the problem is that most often the bar examiner is white. And they have things we call them red herrings. They're things that give you away in terms of your culture, your ethnicity, race. And a poorly written essay question, essay answer will more often than not trigger some sense in the examiner that you are black, or you're Latina, or you're poor white. You're somebody who's not in the club that you're trying to get into. And so you have to teach how to write the answer, how to do what we call the call of the question. And we have to teach things like whenever an examiner is testing you, reading your exam, they test for all those things. So when you go to a job interview, a firm needs to know that you write well, you reason well, and you know enough of the law that if you don't know it, you know where to find it. So you know how to do legal research. You can't do any of that if you don't understand what are they asking you. They ask you if he murdered anybody. They ask you what charges might he be, John, charged with. So a part of it doesn't require you to conclude that he's guilty. Somebody said he's guilty of murder, but they didn't ask you that. They ask you what charges might he be confronting. So what I teach is how to avoid the red herrings, right? How to answer what we call the call of the question. And you don't have to show them that you know the whole law on property. You know, what can I inherit if my mother dies or something like that. They ask you questions to decide whether or not you know enough about how to find law, or if you know the law, and if you can put it in a proper context and structure and do it well, write it well. And that's what I teach when I teach law review.
This concludes my interview, or better yet, Auntie Vickie's monologue. If you want to know more about Auntie Vickie, check the description in this audio video. Thank you for your time and for listening to this episode. If you have any questions or comments, you can find me on Instagram at @2micrófono. If you like today's topic, please click on the like button and don't forget to share it. See you later.